about that in the end. I like this, provide for administrative appeals of quasi-judicial actions. I haven't had a chance to go through your code to see how or to what extent your code allows for administrative appeal. And what I mean by that is somebody that has gotten a decision on usually a ministerial type permit or even a quasi-judicial permit, to have a way to go to an administrative tribunal, preferably a hearing examiner, for an appeal of that before going to court. And again, if you can do that, it's a good safety net for the city and allows for another kind of area or line of review of decisions. And then, things like, trying to integrate your permit process. GMA encourages that. There's specific statutes under regulatory reform for that. Your code should specify, if it doesn't already, which decision makers make which types of decisions. And, so who's going to make decisions on short plats, on conditional use permits, on variances, on site plans, things like that. And then the decision maker, are they making a recommendation on those types of permits, or is it a final decision? Makes a big difference. And I'm not telling you one way is better than another, but I'm saying your code hopefully lays that out and defines it so everybody knows what the rules are. And then ultimately, if there's an issue over how things, what decisions should be made by what body or entity, what type of appeal, talk to your city attorney and work it out to find a process that works for the city of Snoqualmie, that fits your niche. And this is why a lot of this stuff really needs to be kind of fine-tuned to your community, your city. I've been asked by a couple other cities to do work for them, helping them with their code, and on one of the meetings I came in, it's a very small community, one of the planning commissioners came in and said, hey, I got a great sample for us to follow. The city of Seattle's got these regulations, we could just adopt them wholesale. And I said, look, you can do that if you want, but do you want to be the city of Seattle? Your community, you got, 4,500 residents, and you're looking at a city that's got, 1.5 million residents in the greater Seattle area with hundreds of pages or thousands of pages of regulations. Is this what you want to model your city after? And they go, oh, you're right, that doesn't make any sense. And I said, the particular section this person was referring to was literally 30 pages of single-spaced regulations on a particular zoning issue. And I said, that's just not going to work for you folks. You can get this down to, one paragraph, probably. And, but the point is, tailor the legislation you're looking at to the goals and interests of your community, the size of your community, and what you're trying to achieve. All right. So let's turn to the kind of high-risk area that I've been talking about, quasi-judicial decision-making. And like I said, this is a judge-like decision, so you're acting like a judge, made by a council, hearing examiner, board, commission, or staff. And the elements are contested land use application. So some application for some kind of project permit by a property owner or an applicant for a property owner or developer relating to a specific piece of property or groups of properties that goes through a process and has a hearing and has standards associated with that particular permit that ultimately is resolved by an assigned decision maker, whether that's city council, hearing examiner, or some other entity of the city. And so this is the actual definition from actually the appearance of fairness provisions of the state statutes, and it gives you a good definition. They're local decisions of local decision-making bodies, and that determine, quote, the legal rights, duties, or privileges of specific parties in a hearing or other contested case proceeding. This is not area-wide. It's not done for the general public welfare of the city of Snoqualmie as a whole, but to determine rights and use of property and a permit approval for a specific property or specific applicant for that property, and they don't include legislative actions that we've just been talking about. Okay, so it's different, higher risk, and completely different standards. So here's a little cheat sheet and it's a non-exclusive list of examples of quasi-judicial decisions. And there are a lot of things we've already talked about here, things like plats and short plats, site plans, variances, conditional or special use permits, things like PUDs, a planned unit development, or some cities call them a planned residential development or planned residential district, or mixed use development, or things like that. Variances, waivers, reasonable use exemptions from your critical areas regulations, shoreline permits, boundary line adjustments. Some of them, depends on how your city defines those. Site-specific rezones, that is, they just deal with a specific piece of property or so. And other property-specific permits or approvals. Those are examples of quasi-judicial decisions. So when you see one of these coming before you, either for a hearing to make a recommendation, or a hearing on a final permit, or to make some other action, take some action with respect to those, be thinking quasi-judicial, be thinking acting like a judge, be thinking follow the rules that are applicable to a judge deciding a contested case before the judge. And we're going to talk about some of these rules. So here are some limits, kind of the big limits on quasi-judicial decision making. And I'll go through kind of the big headings here. There's a lot of information packed in here, but I wanted you to kind of see what kind of lays the groundwork for quasi-judicial decision making. There must be standards to guide the decision-making process, okay? And where do those standards come from? Well, first and foremost, in most cases, they're going to come from your own code, okay? So that's why I told you early on, if you've got an application, quasi-judicial application coming before you, whatever, planning commission, council, whatever, first thing to do, I think, is pull up your code and look at the standards that are applicable to that particular type of application. If it's a site plan application, I would assume your code has standards applicable to binding site plans and has a process attached to it. Pull them up and get a list of them put together. I actually do a lot of training for staff, and one of the things I tell them up front in their staff reports is to first and foremost identify the project, identify the application, and under a separate heading, just incorporate verbatim the actual standards that are applicable to that particular application. Okay? So it's a plat, site plan, conditional use permit, mixed use development agreement, whatever, plug them in so everybody knows up front what the rules are. Okay? Yes?
When a matter is ultimately going to come to the council, acting in a quasi-judicial manner, but it first comes to the planning commission, does the planning commission conduct itself in a quasi-judicial manner? Or do they act differently than we do?
No, great question. They act in a quasi-judicial manner also. They're bound by the same rules that the city council would be bound by, and I assume in that case they'd either be, the planning commission would be acting in a role to make a recommendation, or they would make a final decision that would be appealable to the city council. Either way, they're still acting as a quasi-judicial, in a quasi-judicial capacity. They're bound by the same rules city council is. Great question. And so you follow that through. So one level doesn't get a different standard applicable. It's the same throughout. So if we find one of those applications or projects that on the preceding slide is before you, when it starts off, it's quasi-judicial, and then when it ends up, it's quasi-judicial. Follows the same rules, same process. Okay? And I'm going to talk about this too. Appearance of fairness doctrine kicks in for all quasi-judicial actions, and I'm going to talk about this. I've got a number of slides on this, but the appearance of fairness requirements inure to both the planning commission and the council also. Okay? So anybody that has a step in the process for a quasi-judicial application is bound by appearance of fairness rules and all these quasi-judicial standards and limits we're talking about. Okay? All right. Decision makers must not interfere with the process. And what I mean by this is when a quasi-judicial application is making its way through the city, starting with probably a staff meeting, staff review of an application, staff recommendations, then it goes to the planning commission perhaps. The final decision maker, that's the city council, cannot interfere with the process and try to guide a result by the lower decision maker. That is completely improper. It is a definition of arbitrary and capricious, and it's just a recipe for invalidation of the decision. And I've seen this so many times, it just makes what little hair I have left curl on my head. Because, and I've seen examples where, for example, this is a common scenario. The Walmart's coming to town, okay? Everybody knows how fun those are to deal with, right? And word goes around that, Walmart's looking for property in the city of Snoqualmie to open a new superstore, okay? And man, word's going around and emails and letters are going to the elected officials, and an application comes in, or a pre-application for site plan review by Walmart. Just an example, of course, and the elected officials are getting flooded with the emails, and I've seen this in other cities, believe me, saying, hey, we can't have this in our city. Okay, so let's stop for a second here. That's going to be quasi-judicial, no doubt. They're applying for a site plan approval, may need a conditional use permit, they're probably going to need a building permit. All of those are going to trigger quasi-judicial rules that we're talking about here. I've seen this in at least 3 other cities where the elected officials start sending emails to staff going, hey, we understand that Walmart submitted an application for site plan review. I want to advise you right now that my constituents will never stand for a Walmart in this city. We can't allow it, and I want you to scrutinize that application, and you make sure you find a way to deny it or condition it, and see if you can limit it to, only 50,000 square feet instead of the 350,000 they typically want, whatever, okay? And I'm not making this stuff up. This happens. In fact, I'm handling an appeal for a city that will be unnamed at this point, where that exact scenario happened and got the staff all in a flutter, and then one of the staff members quit because they felt undue pressure by the elected officials on their independent decision making. Okay? You cannot do this. Okay? Yes.
I know we're running low on time, right? We have 7 o'clock. Yeah, how long is it go?
It's cool.
As long as you and
Never mind.
No, I'm sorry, and I'll try to zip through this.
Yeah, this is the me, Sean.
Okay.
Yeah.
Sorry.
All right.
Try to keep you going here. Okay. I'll try to zip through this. Okay, so anyway, my point is, don't interfere
Sean,
with
did
the
you have a
process.
question?
So I actually had a question. I
Oh,
wasn't
okay.
question your ability to self-harm. I need to question mine.
All right.
So I'll give you the quick scenario, now that we have until midnight, although plenty of the extracts in some all family at 9:40, just for the record. We made a decision last week. We had a public hearing on the noise ordinance, and an amendment to the noise ordinance.
Okay.
And we gave an opportunity for citizens to parade through and offer their opinions on what they thought. And then we made a decision,
Okay.
which was to deny the variance from the current code. When I read that last paragraph on that page, and maybe it's because it's not a quasi-judicial issue, but it tells me that we're kind of sort of not supposed to pay attention to what the public thinks, which is, to use my Microsoft word, orthogonal to what we, I think, as elected officials feel like our duty is, which is to listen to the public and to represent them. So help me rectify that statement at the bottom with what sometimes I think we feel our responsibility is to our constituents.
Okay, you kind of hit the nail on the head of a big part of what I'm preaching here tonight. I don't mean to use the word preach in a kind of beat you over the head type of way, but trying to explain. Okay, great question. So let me ask you a question first, so I give you my best answer, and then Bob can chime in if I'm going overboard. You will not want me to.
No, that's fine. I just was gonna supplement the question with that the noise ordinance applied to, on an area-wide basis to 3 different zoning districts, and so was an area-wide legislative, action, not a quasi-judicial action.
Okay,
It was,
perfect.
it was prompted by a request from a particular property owner, but the ordinance was area-wide in effect, had it been adopted.
So let me amend my question to something that's absolutely quasi-judicial. Okay, over the next 3 weeks, we're gonna hear public comment from a developer and from the public on the annexation request.
And the annexation is also legislative.
No, that's my slide. Are you paying attention?
Okay.
No, I'm just kidding. I'm giving you a
So,
hard time.
third one, right? So the mill site. There we go? Okay, awesome. So proposed, development at the mill site,
Okay,
okay? We're gonna have, I'm sure, floods of public comment and opportunity for people to express their pleasure or displeasure with what is being proposed out there by a developer.
okay.
So is that just a thing to make us look good, to make it sound like we care what the public thinks? Or are we supposed to disregard, as it says there, what the citizenry thinks?
Okay, great question. Let me back up. I'm gonna answer that. I wanna circle back real fast, and Bob can correct me if I'm off base on some of this. The first one of your questions, though, caught me, and I think Bob clarified, because he used the word variance when you were talking about the noise ordinance. Is there a variance application at issue?
I'm
Okay.
new here.
No,
this is
and
the word.
it's not a slight. No. Perfect. Just wanna make sure I'm understanding. So, first of all, with the noise ordinance, as Bob described it, this is perfect, because it circles right back to what we've been talking about. That is a quintessential legislative decision, okay? Low risk, broad authority, you can listen to citizens all you want, and you should. In adopting legislation, you should. This is why I'm harping on the distinction between legislative and quasi-judicial. It's really crucial, okay? So, good point. On that one, you did the right thing. Listen to constituents. You can talk to them at the Starbucks, whatever. The second one was, I'm sorry.
Annexation.
Annexation. That's quintessentially legislative also, same thing, okay? So that makes those easy, and you should involve yourself and listen to citizen comments on it. That's what the law allows for and encourages. Now, third one, I don't know what, excuse me, so you get me all choked up every time I ask a question. I'm just giving you a hard time. So, I assume what you're talking about, there will be an application coming in from an owner or developer of the mill site. I don't know anything about this.
And there is an application pending
For
a planned commercial industrial master plan, which is a type of approval. There's a separate chapter for it in the land use chapter of the code, and that it's 1720 for those following along with their program, 17.20. That has a set of criteria, and then it also says that the process and additional criteria for notice and hearing and decision will be those criteria in the planned unit development or the PUD chapter of the code, which is 17.50. So we have an application, it's pending. It is a quasi-judicial application subject to already adopted criteria in 2 different chapters of the code.
Okay, perfect. So that explained that. So, on your good question, Bob's right. Without even using those words, I could tell you that's a quasi-judicial application, quasi-judicial process. It's listed on my slide, the one couple before this, or 2. Let's look up there. PUD, PRDs, PD, mixed-use developments. I assume it would fit into one of those. It's clearly quasi-judicial. All these rules we're talking about with quasi-judicial kick in at every level. You should not be taking citizen comments, and you're gonna see, move forward, because you actually kind of picked up on some stuff that I'm gonna cover, or we've started covering. As you act like a judge, whether planning commission, you're making a recommendation to the council, or the council's making the final decision, you do not take input from citizens, at least comments about things like, this doesn't fit within the community style, it's too big, we don't like this type of project, not in my backyard, all of those things are not appropriate considerations for a quasi-judicial application. And I know that's frustrating, and I can probably read your mind, because you don't know how many times I have spoken on these topics over the last 20-some years, and I hear this all the time, like, the standard comment is, gee, Mr. Walter, A, you don't live in this city, I do, and B, I got elected so that I could get input from citizens on these types of controversial applications, and don't dare tell me I can't do that. They don't like hearing this, and I'm just the messenger, but I'm telling you that's what the law is. It's very clear, the idea is that the policy decisions underlying the criteria Bob referenced that are applicable to this development project for the mill site have already gone through a public process at some point when the city either adopted or amended its comp plan to deal with that area, or adopted or revised the regulations that are applicable, as Bob mentioned, or at some other stage with the regulations and criteria. There's been a public process. We're at a stage now where there's a contested application coming in that fixes specific quasi-judicial rules. It's these rules, and the last quote at the very bottom here, which is what you were talking about, is absolutely applicable to that type of project. Did I say anything out of line there?
No, can I chime in?
Yeah, please, no.
And this is not to say that you can't listen to members of the public during the appropriate points in the process where there's a public hearing, and people step forward to offer comments or testimony. But to consider it and base your decision on it, it needs to be testimony or evidence that goes to the criteria that you are applying to make the decision. So, for example, there was a case involving a cell tower in Thurston County, and the decision criteria specifically addressed views from particular locations and the extent to which a proposal might impact those, and people came forward and testified, well, my property's here, and here's the view, and this is exactly within the criteria of the code. If it's addressed by the standard, then it's appropriate to base a decision on it. If it's, and Mike's gonna talk later about evidence, but if it's just, as Mike said, I don't like it, not in my backyard, this case talked about just community displeasure, not having anything to do with the standards, then you got a problem.
Well, I could, so take the point, like, the donut you can't use that as a location. And there is a part of the county totally surrounded by the city. They were gonna annex it in, because, you know, said, I really can't fix it anyway, you take it. But you could have a law in there that says, any particular area, geographic area must have 2 exits for safety. That's the standard you would apply. Isn't there a little bit where you can listen to the public and say where those exits would be to the greater community?
I'll answer that this way, and that is, short answer, no, unless your code provides a standard saying that to determine appropriate exit and entrance, the city should consider interests of the surrounding residents, or something like that. Absent that, what you've described, and by the way, I know a little bit about that, it's an technical engineering and safety issue, not a, let's get as many people to talk about their preferred entrance or exit. So my answer is, unless there's an actual adopted standard or provision in the code which would allow the decision maker to take input, exactly as Bob was talking about, from citizens on that, no, we should not. Sorry, a lot of this is frustrating, I know, yes.
Well, Mike, I guess we've been this through a couple of times. The way I've always kind of simply understood it is that you can, well, first of all, it's important to say you've been talking about citizens, but it's also just important to say you can't have the same conversations as a council member with developers and the other interested parties.
Absolutely.
For all the same reasons.
Absolutely.
But again, to think of it like a court hearing, just like a jury that might be sequestered, the whole idea is that any influences on your decision have to be out in the open and on the record. So you can hear whatever you want from citizens, but it has to be in some context where that's captured on the record, or the same thing for the developer. So either
Okay, and I generally agree with that with two caveats. One is, those comments are made at the proper time as part of the quasi-judicial hearing, number one. And number two, the comments relate to criteria in your code. That is crucial. So it's not sufficient to simply say, we're gonna allow citizens to come up and testify on this controversial mill project at a quasi-judicial hearing and have them basically say, gee, this is pristine land and we don't want it developed, and oh, I don't like this developer, he does shoddy work, which I've heard this before, and things like that, that have no basis or no connection whatsoever to the criteria in the code applicable to that specific project. That is key. And frankly, I tell the cities that when you're conducting hearings like that, unless you want to run the risk of having your decision invalidated, that the chair of that hearing, and I'm going to talk about this in a few minutes, needs to control the comments of the citizens and the developer. I'm not trying to exclude the developer, but this is typically comes from citizens want to kind of take a look at a specific project and get back to going, you know what? I just don't think that's really good for the city of Snoqualmie. It doesn't fit within our vision, or it's just not in the right area, or things like that. Those decisions have already been made. The chair of that specific hearing needs to control the citizen comments and questions to keep them focused on the criteria applicable to that project. Okay. I mean, does that make sense to everybody, or am I like really going up?
Isn't it part, so we don't like big box Walmart, the time to really make that decision for the quasi-judicial, when you're talking zoning, you can then zone in, this is zoned for these size of buildings with these size of footprints, so that you set the criteria beforehand, before you get into quasi.
Perfect.
Once you get into quasi, it's too late.
Perfect, perfect, exactly right. You make those legislative decisions up front through the process, and at that time, you take in all the citizen comment you want about this meets the vision for Snoqualmie, it fits with our, this specific zone, it's the right size, this size is too big, we want frontage improvements required, or we don't want this type of ingress, egress. That all gets done legislatively up front. You hit the nail on the head. That's exactly right. Yeah, are you a planning commissioner or council member? Or?
No, but I'm running for city council, and my question is.
No, Monica, I'm sorry, we're not taking any, Monica, we're not taking any public comment tonight, I'm sorry.
So you don't want them to know that it's a heavily contaminated site and the Department of
That's
Health
not relevant to
signed
the,
off on
to
it?
the conversation
That's
tonight.
okay, we can keep the public quiet.
All right, well, and I assume you'll have other opportunities to discuss all this. When I'm trying to cover the ground rules here, let me zip ahead, because you're asking great questions. You folks, all of these questions kind of hit right on what I'm trying to emphasize here. Let me go through a few more of the quasi-judicial limits. Believe me, I've done so many of these presentations over the years and talked to so many council, and I've defended these kinds of cases. So believe me, I'm not saying this just to, as kind of an ivory tower, like, hey, this is the way it should be in utopia. This is what happens when these rules aren't followed, and it's frustrating. And I will tell you, the one comment, if I could have a nickel for every time I've heard the comment from cities all over the state, is I got elected to step in and stop these big projects. I got elected to listen to citizens about these development projects and consider their concerns and make sure that this type of project doesn't come into our city. If I had a nickel for every one of those, I would be long retired. It's just the standard response, and I get it, because it's tough. If you are an elected official or you are a citizen on a planning commission, it's very tough to divorce yourself from your constituent needs and desires versus what the law mandates you do and how you do it. I know it's tough and it's frustrating. I don't make these rules, I'm just the messenger. It does segue to the point that I'll make in a few minutes, and that is, this is why a lot of cities, more than not, are using hearing examiners for these types of decisions and these types of hearings, so the elected officials don't have to involve themselves in these types of conflicts, is the best way I can say it.
So can I ask you one more question?
Absolutely.
So if we have a quasi-judicial decision coming up, say on an affordable housing project,
Okay.
well, we can't talk about that project, given that all of us, except for one person is up for reelection, can we generally talk about affordable housing and what our beliefs are about affordable housing in our campaign, or are we better off?
Okay, so that raises, I think, two concerns in my mind, and maybe more. Bob might even want to chime in. One of them is appearance of fairness issues. So there is an exception for the appearance of fairness rule that does allow legislators or potential legislators to opine on particular types of project and developments within the city without violating the appearance of fairness doctrine. And I'm going to talk about that a little bit later too. But, so that's one aspect. You're probably okay not violating the appearance of fairness doctrine. However, if you go too far with those types of campaign comments, and I see this all the time, such that it shows that you have prejudged a specific application, like if you come out and say, well, you know, I'm not in favor of, or I am in favor of affordable housing, and the perfect spot for it would be XYZ property where there's an application pending for affordable housing, and I think that ought to go through. It's the perfect spot for it. I'm all in favor of it. You've, I think, gone beyond avoiding an appearance of fairness issue to prejudging, and frankly, that is something I would, if I were the person in that position, would disclose that at a hearing, say that I did make these statements, and let somebody from the audience say whether they're gonna, you know, ask to have you recuse yourself or not, and then make the decision on that. So it's mainly an appearance of fairness issue, but it is very hard to try to separate campaign discussions from these types of quasi-judicial decisions, and I guess my comment would be to try to keep your, you know, campaigning comments as generic as possible and talk in policy levels and not try to implicate specific properties, specific projects, or things you know coming down the road. And believe me, I'm not frivolously mentioning the Walmart example, because there's 3 or 4 cities I've done work for where that has been the campaign issue, and in every one of those cities, one or more of the elected officials made statements, and they were asked to recuse. They had to recuse themselves from decision making. So then you kind of defeated your own campaign effort, right? You gotta go, I should have kept my mouth shut, right? So I'm being a little flippant, but that's so the better part of valor. What's that?
It's basically a catch-22.
It is a catch-22, and I mean, I get it. I mean, there's citizens sitting here. I'm not an elected official, but I have a lot of empathy because I represent and defend them, and it's a tough line to